Welcome back to AutoScoop with your host, Adam Goldfein.
Welcome back to AutoScoop. I'm Adam Goldfein. I'm being joined by Richard Griffin, one of Atlanta's top personal injury attorneys. And I'm truly begging you, if you have a question and you're watching the show and you find this interesting, you say, you know what, I got injured a year ago. I got injured 2 years ago. You know, can I still recover? Maybe I delayed. We want you to call Richard and have the conversation with him. He's offering his services free of charge to any viewer that wants to have a conversation to determine whether or not you have a case and how much your case might be worth. And we're talking about what makes a great case. And we've already talked not only about the speed or the importance of hiring the right attorney. We've talked about the types of damages somebody has. I'd like to talk to you about maybe the negligent act of the person, okay? Because, you know, a broken bone and I didn't mean it, or a broken bone and I took a bat, two different cases, right?
Absolutely.
Okay, so when you mentioned like the 18-wheeler, you know, it doesn't mean just because there's an 18-wheeler you're in big trouble, you know, that you get this big settlement. You're looking actually for certain things that demonstrate the negligence, and that's really the difference. Because some people say, well, I got hit by an 18-wheeler, I don't need him, I got this thing covered.
Right. The bigger the case, the bigger the need is for an attorney. I mean, I can help on every single case, but those 18-wheeler cases and other things, there are specific laws which govern what the truck driver can do.
Well, like, give me an example of something that the person at home on the couch eating potato chips right now doesn't know that you know, that they go, oh yeah, I got to get Richard.
Right. Well, an example is that they're not, the federal driving regulations say that truck drivers are not supposed to drive more than 11 consecutive hours. They keep a log, and the logs, you know, are kind of, can be controlled by what the driver puts in there. Drivers typically are paid by the mile, so they're going to try to drive typically as far as they can in as short a time as they can, which means they may be speeding. You can, a lot of times with logs, kind of determine speed even by how quickly do they get to the next destination.
Especially if they're trying to like stay under the 11 hours and they shortchange it, that they're setting themselves up for a speeding situation. Well, how'd you get there in 10 hours?
Right.
You know,
the other thing is there's some new technologies out there which utilize GPS, and 1 out of the 4 largest trucking companies utilize it, where there is no potential user error or user, you know, misrepresentation in the logs. The driver doesn't write down anything. Basically, it's going to use GPS to determine how long he drove, how long it took for him to get from point A to point B. That is incredibly useful, and that's something that as a trial attorney during the discovery, we would certainly want to find out if there was that. You know, you want to get the logs, but you also want to see if that was one of the companies that has that new technology. If they have it, then you've got concrete evidence as to what happened. They're also not supposed to drive more than 60 hours in 7 days. The biggest cause of accidents from 18-wheelers typically is either distraction, speed, fatigue, you know, driver fatigue.
So let's talk about the distraction and the fatigue, because I've seen a lot of studies on with kids and texting, adults on cell phones, falling asleep while you're driving. Are those the types of things that would demonstrate a greater sense of negligence and then in turn a larger award for the injured party?
Well, it would. In fact, if the negligent act gets to the point that it is egregious, it is a reckless disregard for human life, then you even get punitive damages, which is a punishing damage for that action. So there's usually that's your drunk driving, your racing, your hit and runs where you hit, you don't care what you did, you're leaving, you're fleeing the police. All of those things are going to be punitive damages, and that can be a huge, huge value if that's there. But there's also the fact that depending on the negligent act, a jury may be very motivated to deliver a much bigger verdict if it isn't just a, you know, it was raining one day and I slid into another car, if it was that you were going excessively fast, or if it was you were texting. It actually was a study where 19% of the drivers surveyed actually text while they drive on occasion. Well, that is unbelievable. I mean, if you're texting, there's no way you can be watching where you're going.
I think that number is low.
Well, that was just for texting. There's 85% of drivers surveyed that talk on the cell phone.
Okay, because I was going to say, because there's almost like not a car, and, you know, let's be honest, right? People are on the phones. And the interesting thing I've seen from the studies of the phones is, and this I did not believe until I actually really read into it, because I was like, this is nonsense, was the hands-free devices don't change any reaction time at all. Because I thought, all right, it was all, if you're holding it to your head, you can't turn kind of routine, and so the hands-free, the Bluetooth, the bone in the ear or over the car, that somehow makes it better. when in fact it doesn't.
Right.
And the fact was, what they say, driving while talking on the phone is equivalent to being drunk. And I've seen studies where they showed like an 18 or 19-year-old has the same reaction time as a 72-year-old when they're on the phone. You know, it just impairs their ability to stop and go and see what's happening.
It absolutely does. I mean, the brain kind of disengages from driving and what is traffic doing and how fast am I going, and it begins to focus on the discussions. It's interesting because in another recent study, they found when they had people under the study get drunk and drive through a course, an obstacle course, versus talking on the phone, the ones on the phone were actually worse than the drunk driving. And they also found that for 10 minutes after talking on the phone, they still were less engaged in their driving.
Have you been involved in an auto accident where the other person was on the phone? Did you even see? Did you know? Did you record it? Did you get any witnesses? Do you have somebody that's fighting on your behalf? That's what we're talking about, is how do you know you have a great case? How do you know you're getting everything that you're entitled to? And it doesn't have to just be limited to an auto accident. You could be a pedestrian hit by somebody. You could be in a store and there could be negligence. We want to make sure that you get as much as you're entitled to and you at least have the conversation to protect your rights. So you're unemployed. It's going to be tougher to get a job today with 9.5% unemployment. It's important you get lost wages, you get pain and suffering, you get all the things that you're entitled to. So we're encouraging you to call Richard, have that private one-on-one conversation. If it's something catastrophic, Richard, and somebody can't call or you think it's best to go to them, would you make the effort and go out and talk to them or go to the hospital or go to their home if they prefer that kind of privacy?
Absolutely, yeah. Either myself or someone from my office will always be willing, for any size case, to go see the person who has a personal injury, workers' comp, or social security disability claim.
Stay with us. We'll be right back. Welcome back to AutoScoop. I'm Adam Goldfein. I'm being joined by Richard Griffin, one of Atlanta's top personal injury attorneys. His phone number's on the screen. His website's on the screen. If you've been watching the show and you want to know how much your case is worth, or if you've got a great case, or maybe if you've done something wrong, we want you to call and get that free consultation. Now, I mentioned, maybe if you got injured a year ago, is it possible somebody could still recover damages if they got injured a year ago?
Absolutely. For a personal injury case, you're going to have 2 years from the date of the accident, usually. And if you wait after 2 years, then in most personal injury cases in Georgia, you're going to be barred from any recovery due to the statute of limitations. Workers' comp, usually you have a 30-day period to at least verbally notify your employer of an injury. Can't wait and mention it later. They have to have knowledge of it. Then you also have 1 year from the date of the accident to file your notice of claim with the State Board of Workers' Compensation.
So you have some time, but not that much time.
Right.
So,
and it is a moving target. On the comp case, for example, you're going to have 1 year from the last date you saw a workers' comp doctor that's paid for by workers' comp. So it's really, really tricky on the comp. It's a moving target. So that's especially important not to play with that and know exactly what the statute is.
Right. Well, why should somebody hire an attorney? Let's go through the 2 or 3 benefits of actually having somebody represent you.
Well, first of all, you're not going to have to be concerned. I mean, you're going to have you ask the question and I'm going to give you the answer, or I'm going to find the answer for you. A lot of times that takes a lot of stress off of that injured party. When they know what's going on, they're in the loop, they get their questions answered. We're going to make sure that we are getting them to the doctors. It's amazing how a lot of times they won't treat. They'll wait. They'll say, well, I hope it gets better. Well, if they need medical treatment, they need to get it right then. Because if they don't, then an adjuster or a defense attorney is going to argue in the future. They're going to say, well, if you were hurt, why'd you wait 30 days? Or why'd you wait 45 days
So you're
to go to
making
the
it
doctor?
up, kind of. Instead
You're
of
making
being
it
a
up.
good guy.
But if you do what is best for your health, it's often best for your case too, because then you've got a doctor who says, yes, I saw you on this date, and if it's right on the date of the accident or close to it, and then you continue to get the treatment you need.
Do you actually get involved to make sure that they go to the right type of doctor, that they don't end up at a chiropractor if they should be at a neurosurgeon? I mean, are you involved to make sure that the right doctors are seeing, so the right documentation is there and the right damages are established early on?
We do. I mean, we try our best to give them options. We advise them. We give them, I don't want to just give them one name. I want to give them several names of doctors that I think would be good doctors for them to talk to, because some cases, I mean, typically the treatment plan that's usually the best on most cases is the one where they get treatment as soon as they're in pain. They follow up with their family doctor or with a chiropractor or physical therapist. They treat with conservative care, which may be prescriptions, maybe physical therapy, maybe chiropractic, for a period of time. if you're not better, then you don't want to keep doing it. I mean, maybe you do it for 6 weeks and then you see the specialist because you need to get to the bottom of what's really wrong.
So why, in your experience, do people delay hiring an attorney?
Well, there's different reasons. I think some people, they may delay because they don't want to sock it to the other side. They don't want to get an unjustified windfall. They don't want to, get the $1 million that they're not entitled to. Well, that isn't, that's a valid, concern. That means that person really does care. But what they need to do is not be worried about that. They need to be worried about just getting paid what they should get paid.
Because you're not going to ever get paid more than you're entitled to. I mean, the insurance company's not going to say, oh, you lost a fingernail, here's $1 million.
Right.
That doesn't happen.
When you hire an attorney, that's evening the playing field. That's making sure that you're going to get paid what you're entitled to and not get shortchanged or cheated.
Well, the insurance carriers have their attorneys.
They do.
And they have their jury verdict research.
Right.
And they know what they pay out by claims. And so they're a for-profit business. They're going out there to make sure that they're keeping their claims expense as low as possible. Right? And so if you really do nothing, you're at their mercy.
Right. And they oftentimes base it, there's some insurance companies that have used Colossus, this program which tells them what the case is worth, kind of takes it out of the hands of the adjuster and puts it into this program. Well, that program is not a jury verdict research. It does not tell you what cases have settled for or what jury verdicts have been given. It's just their formula of what they want to pay out. Well, that's not the way it needs to be handled.
That's wrong. Do you find that they, in any senses, will come out and try to get quick settlements, or the people that don't know, or that in a sense that people can get taken advantage of, if they're ill-informed?
Well, they certainly can. A lot of times people will be offered $500 even at the scene. I've heard, they'll send someone out or shortly thereafter, offer them a little bit of money and just sign this general release, and they may think, well, I'm in pain, but I think it'll be okay. Hopefully I won't hurt a week.
It's a very important point. Should they sign anything without you seeing it?
I wouldn't. I would definitely not. I think you need to have an attorney review it, because if you are settling your property damage, you want to make sure that release is only releasing property damage issues and not your personal injury claim.
And I would imagine the same is with statements, right? That you would know, or should know about any statements that they're making, or be involved, or not necessarily allow them to have, free reign and speak to just anybody, right?
That's absolutely the case. If someone doesn't tell the full truth, for example, a lot of times people are asked, have you ever been in an accident before? And people go, I don't want to tell. Well, if you don't tell, they have databases that know, so that's going to hurt your case. You need to tell the truth. Likewise, when you're describing how the accident happened, you don't want to just guess at speed, distance, time. You want to make sure that you tell what you know, and you get pushed into making these conclusions that may prove to be not true.
Here's what it's about. It's about getting a fair, reasonable compensation for your damages so you get the most for your case. And if you're unsure, call Richard and ask him and talk to him personally. We'll be back with more AutoScoop.